Hello, thank you for signing up for this course. My name is Amanda Cummins. I'm a licensed Florida attorney. I practice primarily in St. Petersburg, Florida, but I do cover multiple counties on the west coast of Florida, as far north as Marion and as far south as Bradenton. I practice primarily in the areas of family law and wills, trusts, and estates, and that includes probate, estate planning, guardianship, and veterans benefits. I created this course as an informational tool for any individual that's going through a divorce or contemplating filing for divorce. It's not meant to be legal advice for your specific situation. It's just to give you information about the process, how to prepare yourself for divorce, and then to actually file for the divorce if you decide not to hire an attorney. A common misconception that I see is people automatically assume that they must hire an attorney, and that may not be the case for your family. Attorneys usually are encouraged if you're in a highly contentious divorce, so you and your spouse do not communicate well at all, there's a complete breakdown of your relationship. In that case, an attorney might be appropriate. And after you've watched this video and helped gather some of your documents, then it might be wise to consult with one or more attorneys to see, different courses of action you may have. I am a Marine veteran. I served on active duty in the Marines. I was a legal assistance attorney, so I helped with landlord-tenant issues, estate planning, and uncontested family issues. And I also served as a prosecutor, and most of my cases involve special victims or computer crimes involving children. So I try to implement a lot of my experiences that I gathered from working with victims and families going through very tumultuous times into my practice. So this is just a course to give you an idea of what to expect and try to help you mentally prepare for what's going to happen. So let's go ahead and get started. So the first thing most people say is, help me, I do not even know where to start. I have no idea what to do, I don't know what to expect, but I know that I need to get a divorce. So we'll walk through that. So the first thing we're going to talk about is costs, so how to prepare. So costs are not attorney's fees, they're separate. It's the cost of filing for the divorce, and there's certain costs that may or may not be able to be waived. So if you are indigent, so if you fill out a form, an application for the court to determine that you're indigent, meaning you're below the poverty line, you can get your filing fee waived. So the filing fee is what it costs to open your divorce case. So it's $408. You go to the courthouse, you file your paperwork, you're going to have to pay the clerk of court $408 to open the case. And the next fee is going to be the summons. So the clerk has to sign what's called a summons, and the summons is the paper that you're going to serve your spouse with, and that legally brings them into the action. So the court can't move forward with your divorce until your spouse has been served. That being said, you're going to have to hire either a sheriff or a process server. Sheriffs are usually around $40, but again, it depends on what county you're in. And a process server costs somewhere around $65 and upwards. So that's a certified person who has a certification with the state of Florida, or a sheriff that is certified to serve legal papers on defendants. So you file a suit, you hire a process server or a sheriff, they go out and serve the other party. If you have children, you're going to have to take a parenting course. It's legally required in the state of Florida if you have children to take a parenting course. And that's usually around $65. There are some that are cheaper, and again, there are some that are more expensive. Another thing that you're going to have to do is mediation. So the way the divorce process works, which we'll get into that a little bit later, is mediation is a facilitation of a conversation. A mediator is certified, and they're usually an attorney, but not always. They could be a mental health counselor or a therapist, psychologist. They go through training to be mediators, and they either sit you and your spouse in separate rooms at a physical location, or they can do it over Zoom, and they try to help you and your spouse come to an agreement so that you don't have to go to a trial. That's going to be required in almost every case in Florida. Very rarely is a judge going to waive mediation, and that's going to be about $65 or more. And then if you do hire an attorney, you can expect to pay a retainer of about $2,000 and upwards, depending on your location. Some counties are more expensive. And then the hourly rate for attorneys is usually anywhere from $250 upwards. So attorneys' fees are going to vary depending on your location. So an attorney in Miami-Dade County is obviously going to cost more than an attorney in Okaloosa County. The cost of living is different there. Additionally, the number of years the attorney's been practicing, whether or not they're board certified, which is a specialization that an attorney can get through the Florida Bar Association, which basically means they're an expert in that area of law. So if you hire a board certified attorney, you can expect to pay $400 an hour or upwards. Attorneys usually bill in 6-minute increments, so if you have a phone call with your attorney, it lasts 4 minutes, you're going to get billed for a 6-minute conversation. So it's they break it down in tenths of the hour, and that's what you're billed at. So that's something to keep in mind. Next, we're going to talk about documents that you need to prepare. So some of the documents that you need to get ready are what's called mandatory disclosures, and we'll go over that in more detail later. But first things first, you're going to need a copy of your Florida driver's license, which has to have been issued at least 6 months prior to your divorce, and that's just to prove Florida residency. You're going to need to, if you have children, file the certificate of completion from the family course that you took, the parenting course. You cannot waive a financial affidavit, so each party will have to fill out a financial affidavit. And what that document does is it's used to determine what assets you have as a married couple, what liabilities you have, your income, your spouse's income, and how the court will look at that and run child support based on that, or make a determination about alimony by the financial affidavit. You're going to need the last 3 years' tax returns, so either your tax transcript you can get through the IRS or the actual tax return that you filed. You'll need 6 months of pay stubs, and that's from any source of income whatsoever. So if you're a salaried employee or an hourly employee, you get a pay stub. You need 6 months of those. If you have a side hustle or a passive income stream, you're going to have to show 6 months of any income received from whatever source, whether job, passive income, investment, that kind of stuff. The other thing that's important is any applications for credit within the last 2 years. And the reason that that's required is sometimes people will be dishonest on their financial affidavit, and that's one thing that I usually look at is what they're listing on their financial affidavit as their income, what their pay stubs say their income is, and then if they've applied for credit. So if you've ever applied for credit, a credit card, a car loan, or a mortgage, you have to disclose your income on that application. So if your spouse applied for a car loan and is telling the bank that his income is, or her income is, $10,000 a month, but on their financial affidavit they say they're only making, $2,000 a month, that's going to be something that sparks my interest, and because there's a discrepancy there. So either they commit fraud on the application for that credit and they lied about their income to get credit that they would not have qualified for, or they're being dishonest on their financial affidavit. You're also going to need deeds to any real estate that you or your spouse owned within the last 2 years. So if you and your spouse own, a vacant parcel and you sold it a year and a half ago and then you bought a new house, or you have a house, even if you sold the property, you have to disclose that deed. Bank account statements for the last 12 months, that's all bank account statements at whatever bank you have. Bank, credit union, if you have checking and savings accounts, those need to be disclosed. Money market accounts, those need to be disclosed as well, and you need 12 months. Brokerage account statements, so those are your investments. You're going to need the last 12 months of those statements as well for any investment account that you have. And retirement account statements, so this may be if you're a state of Florida employee, you're a part of FRS, that could be your FRS statement. If you're in the military, it could be your thrift savings plan statement. If you have some sort of IRA, 401k, a SEP, or a simple plan, something to that effect, you'll have to provide 12 months of statements. And a new one is virtual currency. So a lot of people are investing in cryptocurrency or some sort of blockchain technology asset. You'll have to disclose 12 months of those assets as well. life insurance policies. So this is going to be cash surrender value policies. So if you have a cash value policy, a life insurance policy that's accruing a cash benefit, then you need 12 months of those statements as well. If you have dental or health insurance, you need a copy of your dental or health insurance card. And if you own a business, you're going to need the last 3 years of business tax returns for your business. And then credit card statements, this one is any credit statement. So credit cards, car loans, that kind of stuff, you're going to need 2 years, so 24 months of those statements. You're going to have to put those together. If you or your spouse entered into any premarital or prenup, postnup, premarital, postnuptial agreements, you're going to have to disclose those as well. And then any court orders of you or your spouse to pay child support, and that's for the children of this marriage or children outside of the marriage, and that's just to help, again, run those numbers for child support if you or your spouse do have a child or children together. So the next thing we're going to talk about is the pleadings, the court documents. These are documents you're going to draft and file. They can all be found at this website, www.flcourts.gov. They have what's called Supreme Court Family Law Approved forms. So all of these documents that we're about to go over are on that website. You can either download them as a Word document and type and edit them, or you can download the PDF, print it out, fill it out, or you can type it out. So the first one we're going to talk about is the civil cover sheet. It looks like this. So this document just basically tells the clerk of court of whatever county you're filing in. You're going to file in the county where you last resided as husband and wife, and or spouse and spouse. That civil cover sheet just says to the clerk, this is an initial filing. It is a dissolution of marriage with or without children, or a simplified dissolution. So this is the first document that's going to be generated. It's required to be filed in all cases. The next document is the actual petition for dissolution. I'm showing the one for a dissolution of marriage with children, but there are other forms. There's a simplified dissolution, which we'll go over in a second, and there's also a petition for dissolution with no property. So if you and your spouse do not own any property, you don't have any assets, you don't have any liabilities, then you can file a different form. But this one is, you're going to have to file a petition for some sort of dissolution. And this just basically lists out the jurisdiction. So it's telling the court that this state of Florida has jurisdiction, which means that you or your spouse, one of you, have resided in Florida for at least 6 months. And you either have to prove that by providing a copy of a driver's license that's been issued for at least 6 months prior to filing, or you can get a witness to sign an affidavit saying, I know this person and they've been a resident of Florida for at least 6 months. You also have to disclose whether or not you or your spouse are a member of the military service. And that is to comply with what's called the Service Members Civil Relief Act. And that basically is a law that provides protections for service members, so while they're deployed, they cannot be sued and a judgment cannot be entered against them. And we can, if you are a service member and you're deployed at some point and you get served with a divorce paperwork while you are deployed, you can hold that case in abeyance. So basically it'll be frozen until you return, a reasonable time after you return. So you can't delay it forever, but you can hold it and pause the case until you return, and that's just to allow you to focus on the mission, which is whatever you've been deployed for, and then return and deal with your civil matter when you get back. You also have to disclose the date of marriage, the date or on or about when you separated from your spouse, and then where you got married. So just because you got married out of a state doesn't mean you cannot get divorced in Florida. You have to disclose whether or not you have any minor children. So in Florida, it's presumed that a child that is born during a marriage is the child of the spouses. So husband and wife, say the wife gets pregnant by somebody else while they're married, that child is presumed to be the husband's child unless otherwise proven in a court of law. So you have to disclose whether or not one or both of the parties is pregnant at the time of the divorce, and then you have to list the names and dates of birth of all the children of the marriage. So the next document is what's called the Uniform Child Custody Jurisdiction and Enforcement Act affidavit. It's a mouthful. But basically this document complies with a uniform law, and a uniform law is usually adopted by most, if not all, of the states in the United States. So the uniform, it's the UCCJEA. It basically helps prevent kidnapping. So one parent takes the child and flees the state and, takes the kid with them and doesn't, basically you're trying to hide the child from the other parent. This document requires you to disclose all the addresses where that child has lived for the last 5 years and any adults or other people that have lived with the child. The next document we're going to go over is the Notice of Social Security Number. This is required to be filed in all dissolution cases. So you have to disclose your social and your date of birth and the social and dates of birth of your children. So each spouse will have to fill this out. And because you're filing your social security, you're also going to file a document that protects it from being posted on the docket, so people can't pull up that document and see your social security number and steal your identity. You'll also have to fill out a notice of related cases, and this just informs the court of any other cases that involve your family. So if there's a domestic violence injunction, is probably the most common that I've seen. You would probably want to have all of your cases heard by the same judge. And the reason that is especially if you've hired an attorney, you're going to have to go in front of one judge, tell the facts of your family and about this domestic violence, or if it's a dependency, if DCF's been involved in taking the children out of the home, you're going to have to hire an attorney to argue that case in front of a judge, and then you're going to have to pay that attorney to go tell the same exact thing they just told that judge to the other judge in family court. So the related cases form basically just informs the court, hey, court, there's these other cases that involve me and my spouse and our children, and I want them to be coordinated in front of one judge, and that's just to save time and money, and so that you have one judge that knows your family and intimately, and you don't have to keep repeating what's going on to different judges. The next document is the most important document of the entire case. This is the one that attorneys will spend the most time evaluating, and we compare this with that list of documents I told you at the beginning to get together. We're going to compare what's listed on this to the disclosures that are provided. So the financial affidavit is, like I said, the most important document because decisions about your family are going to be made based on the judge's review of this document. So you must disclose all of your monthly income, and there's certain expenses that are exempt, so they'll be taken off, and that is going to be court-ordered child support, alimony, taxes that you pay. If you are a teacher or if you are a firefighter or you work for the fire department, you have a mandatory pension that you have to pay. So those are going to be taken out of your income, so it'll lower your income a little bit so that you're not paying child support or alimony based on income that's automatically being taken out of your pay, taxes, mandatory retirement. This document's also going to list out all of the assets and liabilities, and you're going to check, whether it was a premarital asset, so you acquired the asset before or that debt before you were married, or if it was acquired during the marriage. So big ones that I see are student loans. So if you or your spouse have student loans and those were acquired before you got married, that's going to be a separate liability. So you're going to be responsible for that and not your spouse. The same goes for your spouse. They'll be responsible for that debt, but you will not be responsible. And this just helps the judge determine what assets there are. So I recommend listing everything that you own on this form. All your furniture, all your electronics, all of your bank accounts, your investments, everything needs to be listed on here so that the judge can determine how to split up stuff if you and your spouse don't agree. The next document is called a Certificate of Compliance with Mandatory Disclosures. You're going to fill this out and you're going to sign it and you're going to file it once you've given your spouse or their attorney all of those documents we first went over. So all the bank account statements, a copy of your driver's license, copy of your health insurance card, copy of your credit card statements. You don't actually file those documents with the court. And the reason is because the court is public record. So anybody can pull that information off the court's website or go to the courthouse and get a copy of your pleadings. So you do not file any of those documents. You give them to your spouse or their attorney, and then this is what you file with the court. And this just tells the court, Your Honor, I complied, I provided my spouse all of the disclosures so that my spouse can enter into an agreement, a marital settlement agreement, or a parenting plan, fully advised of the property that we have acquired during the marriage and the debts that we have acquired during marriage. And it's also to help the judge review all these documents and make sure everything's been disclosed so the court can make an equitable decision based on the facts of the case. Next is a parenting plan. So the parenting plan lists out time sharing and your responsibilities and rights as parents. So it's going to list out the weekday time sharing, weekend time sharing, pickup times, drop-off times, pickup locations, drop-off, who's responsible for what sports, extracurriculars. It's going to list out who's responsible for health insurance. It's going to list out holidays, so any holiday time sharing, that'll all be listed in this parenting plan. So this is what your goal of mediation, if you have children, is to walk out with a parenting plan, because you are in charge. Nobody knows your family better than you do. It's your family. These are your children. These are children that you share with your spouse. Even though you're breaking up, it's still one family because you still have those children together. So I always say, if at all possible, try to get a parenting plan, because it's a wild card when you go to court. You may not be happy with what the judge decides, or your spouse may not be happy, so it's best to keep the power, keep the decision between you and your spouse, so you can determine what's best for your kids and not have a judge who doesn't know you from anybody else listening to your side of the story versus their side of the story, looking at the documents, reviewing text messages, and making a decision. You're really in charge of your family when you come to an agreement with the parenting plan. Otherwise, the judge is going to make the decision for you. Next, you're going to have to file a certificate of completion from a parenting course. So if you go to this website right here, which will be listed separately, you will have access to local courses, so courses that are available in person in your county, or online courses, webinars that you can take, and other providers. And you will take this course, you'll pay for it, and then you'll get a certificate of completion. You have to upload that or file it with the clerk's office before your case can be closed out. It's required by law, not going to get waived. Next, you're going to have to file what's called a notice of filing child support guidelines, and this just notifies the court that there's a child involved and the child support guidelines are going to be filed, which the next document is the child support guidelines. So child support guidelines will be, you take your income, you take your spouse's income, and then you take the number of overnights, and then any expenses that you pay for your child. So if you pay for daycare, health insurance, those will be subtracted. And then the guidelines will calculate who's responsible for child support and how much. So the marital settlement agreement this is your property agreement. So how you're going to divide your property. So either your assets or your liabilities, who's being responsible for what, who gets to take what. If there is alimony, it will be spelled out in here. And this is the document that, again, you're going to hopefully walk out of mediation with one of these signed, because like I said, no one knows your family more than you, and this way you still retain control over your future. You're never going to be 100% satisfied with the parenting plan or the marital settlement agreement, but at least you and your spouse came to that agreement and you didn't have the judge decide. So this will just list out all the property issues, who's getting what, who's responsible for what in your marriage. Also, you'll have to file a copy of your driver's license, and like I said, this is just to prove your residency for the state of Florida. And the summons. So like I mentioned earlier, this is the document that brings your spouse into the course, or into the case. So the summons is signed by the clerk of court, and it commands them to appear before the court by filing an answer within 20 days after the date they're served by the process server. The process service memorandum is what you're going to give to either the sheriff or the private process server, and you're going to tell them the documents that you want to be served on your spouse. And this document will instruct them where to serve them, and also instruct them if your spouse has any weapons. So this is important to disclose because, if it's a contentious divorce and your spouse is not mentally well and they have weapons, that is a concern for you. You should probably disclose it to the sheriff or the process server so that they can be prepared if your spouse reacts in a very negative way. The notice of confidential information, you're going to file this and list out that the two confidential documents are going to be your notice of social security number and the Uniform Child Custody Jurisdiction Enforcement Act, the UCCJEA affidavit. And that just tells the clerk, hey clerk, there's confidential information in this document, i.e. my social security number or that of my children, and I need you to redact it from court record. So they'll black it out. So if somebody asks the clerk of court for a copy of your social security number, they'll either not be able to access that document and the clerk will not give it to them, or they'll get a document with your personal information redacted. Alright, so you're going to get referred to mediation. So you either can get court-provided mediation or you can hire a private mediator. Court-provided mediation, the cost may be free if you're declared indigent by the court. So if you fill out an application at the beginning of the court to have your filing fees waived, then you may, and you're approved as indigent, meaning you are below the poverty line, they're not going to require you to pay filing fees, then you may not have to pay for mediation either. Court-provided mediation in the locations that I practice is anywhere from $60 for a 3-hour session or $125, and that's for court provided. So you would just ask the court, we would like to attend court provided mediation, please give us a referral, and then you'll go to your circuit, which I listed the 6th Circuit, which is where I mostly practice from, and they'll give you information of how to go ahead and get your mediation set up. You can also hire a private mediator, and I have preference of certain mediators just because of my experience working with them. I tend to prefer private mediators that are retired judges, retired family law judges, specifically for dissolution cases, because they're going to advise you what a judge is likely to decide, and they also might know your judge, so they may have trained your judge when the judge that's assigned your case became a judge. The retired judge that's now the mediator may have trained that judge, so they may have an inclination of what that judge might decide if you were to go to trial and not resolve your issues at mediation. Private mediators are usually attorneys, and they usually cost anywhere from $200 to $400 or more an hour. The retired judges I'm seeing are usually around $300 to $400 an hour, and that's something that you need to keep in mind as an expense if you're not going to use the court-provided mediation. You're also able to ask for a referral to a general magistrate. So a general magistrate is an attorney that is going to make an evaluation of your case and provide a report to the judge assigned to your case. The reason I tend to like working with general magistrates is because their calendars have much more availability than your judge. So your judge can have over 3,000 cases assigned to their docket. So if you've thought about that for a second, 3,000 cases, and all these people are trying to get their case in front of the judge, you may have to wait months before you can get in and have a hearing in front of the judge. Whereas if you get a referral to a general magistrate, it's an attorney. They're fully qualified to make a report and recommendation to your judge, and your judge usually will adopt the magistrate's report. And that just gives you and your spouse the opportunity to get into court quicker and to be heard on issues quicker. And another document that I see sometimes is what's called a motion to deviate from child support guidelines. So this can be filed if, say, you do the child support guidelines and the child support obligation is $5 a month. Obviously that's kind of a waste of time to do child support for $5 a month. You and your spouse can agree to waive that, and you can ask the court to deviate from the guidelines. So the guidelines are the guidelines. You can't say, oh, well, my friend only pays, $100 a month in child support. That's because, like I said before, child support's calculated based on your income, your spouse's income, minus any expenses like healthcare or childcare, and the number of overnights. It's a formula. It is what it is. So if it comes out to where it's super low and not really worthwhile, you can file this motion to deviate and ask the judge to just waive child support. So those are the pleadings. I'm going to go through now the process. So the process is going to be, it's not going to happen overnight. So people are like, well, I want to get divorced now. It's going to take months. Now, if you and your spouse agree on everything, you can file and then get a hearing within a month or two, and then you can have it done then. But for the most part, it's going to take several months to get through from the date you file into the final judgment. So the filing of your documents is going to be the first thing that happens. So all those pleadings we just went over, you're going to file those documents. You're going to have your spouse served by a process server, and once they're served, they have 20 days to respond. So if you've been served with documents, you have 20 days from the date that process server or sheriff handed you those documents to file an answer or to request a continuance. So you say, hey judge, I got served, I'm in the process of hiring an attorney or looking over these documents, can I please have some more time to respond? Usually the judge is going to give you more time to respond. Court deadlines, that's a big one. So your financial affidavit and your mandatory disclosures are required to be served on your spouse 45 days after you filed. If you are the spouse that has been served, your mandatory disclosures and financial affidavit are required to be served on your spouse 45 days after you file your answer or your counter petition. A counter petition is, hey, I've been served with this divorce. I agree with these paragraphs, but I do not agree with these paragraphs, and I'm asking for something different. So you're also suing your spouse for divorce, and you're asking for something different than what they're asking. That's called a counter petition or a counterclaim. Know your judge. So depending on the circuit, the judge's information will be listed on the circuit website. The judges are going to have what's called a judicial assistant. It's very important to interact with that individual professionally because they are the judge's right-hand man or woman. And that person is going to be scheduling your cases. They're going to be advising you of court proceedings. And you can also learn what your judge's practice preferences are by going to the website of your circuit. So Pinellas County is the 6th Circuit in Florida. I can go on the 6th Judicial Circuit website, pull up my judge that's assigned to this case, and see how they like their courtroom run. So it's critically important that if it's not listed on the circuit's website, because some circuits don't list the preferences on the website, that you email that judicial assistant. Always copy the opposing party. So you cannot communicate with the court without copying the other party on that communication. So that's called an ex parte communication. So you cannot talk to the judge or the judge's assistant without CCing the other party. And the reason that is because the judge doesn't want any appearance of favoring one side or the other, so they're not going to talk to you. If you communicate with them and you don't include your spouse, the judge's assistant is going to reply to you and CC your spouse and tell you, do not communicate without including your spouse on this communication. And that's just so there's no appearance of partiality towards one spouse or the other. So get a copy of those preferences, read them, and know how your judge likes their courtroom run. So they may say, if you come to my courtroom, don't wear perfume or cologne, because they may have a sensitivity to that. They may say, 4 days before hearing, I need a binder with all hard copies of your documents. They may require you to submit proposed orders, so an order you want them to sign, they may require you to submit that, a hard copy of that, and not just give them an emailed copy of it. So it's very important to know what your judge is like so that you can cooperate with your judge and follow the rules of their courtroom without getting in trouble. Another thing is going to be setting a case management conference. So some circuits, like I know Hillsborough, the 13th Circuit, if you file a divorce or any family case, they'll automatically send you a case management notice. So a case management conference is basically you and your spouse, your attorneys if you have them, will come before the judge. It'll be anywhere from 5 to 15 minutes, and you'll talk about the next steps in the case. Where are we at? What's going on here? Do we need to go to mediation? The judge will issue a case management conference order, and basically that'll set up, mediation for you, refer you to court mediation, or it'll set deadlines for your case. So mediation must occur by this date, and then you must come back for another case management conference. And that's just so your case isn't lingering. It's just to move your case forward. So the judge, you're checking in, telling the judge what's the status of the case, and then you can set your next dates. You need to schedule mediation. Usually mediation occurs 45 to 60 days after your divorce has been filed, but normally it's not going to be set until the parties have exchanged those mandatory disclosures. So it's really important to have those documents ready before you file, because you're going to have to serve them anyways, and that's just so you can hand them over to your spouse or their attorney, and then you can review all those documents before you go to mediation. That way you're entering into a marital settlement agreement or a parenting plan, fully advised of all of the assets and liabilities that you and your spouse have. And then setting a final hearing. The final hearing is where the judge is going to grant you the divorce, and they're going to enter an order of final judgment is what it is. And that's just basically what the document that says you're officially divorced. They're also going to hear evidence if it's contested. So if you and your spouse did not agree at mediation and you need to go to trial, the judge is going to determine what's in the best interest of your child as far as time sharing. They're going to determine what child support should be. They're going to determine what assets are given to which spouse and what liabilities each spouse is going to take over. If there is alimony, they're going to make a determination on that as well. So managing your expectations. So the big one is child support. Child support is a right that belongs to the child. Your child support is not meant to pay all of your bills. So I have had clients, there's no way, they'll tell me there's no way child support's that low. There's no way, I can't do it. Well, unfortunately, you're going to have to, because the child support is not for you as the parent, it's for your child. And it's not going to be, an exorbitant amount of money every month that you're getting from the other parent to help support that child. You both have an obligation to provide financial support, and like I said, the guidelines are the guidelines. Rarely do you see any deviation from them above what they are, and that's just because it's a formula that's been codified in statute, and so you run the calculation and that's the child support amount. So don't get in your head that you're going to get a certain amount of money for child support. Alimony is another one. Some people will come into my office and say, I spoke to another attorney, or I spoke to my friend, and they said alimony is automatic because I've been married for 20 years. That's not true. Alimony is, there's two ways to prove alimony. Number one, you need alimony, or your spouse needs alimony. That's the first one. So the spouse asking for alimony has to demonstrate a need for it. How do you do that? The financial affidavit. If your financial affidavit says that your income every month is a certain amount and your expenses are less than that amount, there's no need for alimony, because your income every month is covering all of your expenses. Now, if your income is coming in, say you stayed at home, your spouse was the primary provider for your family, and you stayed at home, you didn't work. Normally, your income is not going to be sufficient to cover your expenses, because now you're going to be living in two households. You're going to have two expenses for everything, and you may not have the income that your spouse had or the quality of living that you had while you were married. In that case, you, if you're asking for alimony, have to prove that you need it, and then you also have to prove that your spouse has the ability to pay. And how do you do that? The financial affidavit. So if your spouse has a certain income and their expenses are more than their income, they don't have the ability to pay alimony. Some spouses will try to hide their income or misrepresent their income to the court so that they don't have to pay alimony. And how do we overcome that allegation, mandatory disclosures. So like I said, that's super important for you to look at those documents because they can help you prove that your spouse is not being honest about their income or their expenses, and it can be used to prove your need for alimony or your spouse's ability to pay for the alimony. Mediation, it's really important that you manage your expectations for mediation. So mediation, you may go to mediation more than one time. So say you did mediation for 3 hours and you only got through the parenting plan, you can ask to go to mediation again so that you can have a mediator help you resolve your parenting, your marital settlement agreement. So who's going to be getting what assets, who's going to take over what liabilities. So make sure that you don't go into mediation thinking everything's going to be resolved right now, because you may run out of time. You also should not go into mediation with the mindset that I'm not settling for any reason whatsoever. I want to go to trial. It's expensive, it's time consuming, it's super stressful. I always try to encourage my clients to go to mediation with an open mindset and try to come out with an agreement that you can stomach rather than throwing the dice and risking a judge making that decision for you. Another thing is dealing with your spouse or their attorneys. So if there's a breakdown with you and your spouse to the point where you cannot communicate at all, you need to understand that it's going to be very difficult to go through a divorce, especially if your spouse is a narcissist or they're a sociopath or they have some other personality disorder which makes them very difficult to work with. So you need to understand that you're going to still have to continue dealing with your spouse through the divorce process. And if you have children, your spouse will always be a part of your life. Kids turn 18, but they also go to college. They graduate from college, they get married, they have children. So you're always going to have to interact with this person, even though you're not married to them anymore. So that's one thing to keep in mind. And attorneys are not always pleasant. If you are dealing with your spouse's attorney, they are not working for you. They are working for your spouse. They are trying to do what they are able to do that is advancing your spouse's case to their benefit, not to yours. They are not your friend. They are required under the rules of the Florida Bar to act professionally and ethically with you as an unrepresented person. So if you don't have an attorney, they're required to act professionally and ethically with you. But they're not your friend. They were hired by your spouse to represent your spouse's best interests, not yours. So keep that in mind. Always keep it professional. I always say, put everything in writing. If you're talking to an attorney and you don't have one, you need to make sure that everything that you tell that attorney is in writing, because they will try to use it against you. Or you can use that writing, those emails or those letters that you've exchanged, to prove certain allegations that you're making in your case. And often the most difficult expectation to manage is time. Like I said, this doesn't happen overnight. It can take several months for your divorce case from the start to the end. So that's one thing to keep in mind, is how long it's going to take to get through this divorce. Judges, that's another one. Manage your expectations with judges. I've had clients adamantly demand me to try to get rid of a certain judge. I do not recommend that unless it is blatantly clear that the judge is biased towards your spouse. The reason being is, if you file a motion to disqualify a judge, or you file a motion for that judge to recuse themselves, so they have to withdraw from that case, and you get assigned a new judge, they're going to be the one that makes the determination whether or not to grant that request. So you can basically curry bad favor with a judge by filing a motion to disqualify them, and it's not really there's no legal basis for you to do so. Just because you don't like a decision the judge made does not mean you need a new judge. So you need to keep that in mind. Judges are humans. They don't always make the right decisions. They do their best to follow the law. They're required to do that, and they're going to make their decision based on two things: the law and evidence. So what the law tells them that they're allowed to do, they're going to do. And they're going to make that decision based on evidence, and that's going to be in the form of documents. So the financial affidavits, the mandatory disclosures, text messages, emails, anything like that, letters, photographs, all that stuff is evidence. The other thing is testimony. So your testimony, your spouse's testimony, other individuals you may call in as witnesses. So if there's domestic violence and somebody's witnessed that, a doctor, a therapist that's made diagnoses, that's going to be evidence. Them testifying, the judge can make a judgment and weigh the evidence. So they're going to look at your credibility and your evidence. They're going to look at your spouse's credibility and evidence, and they're going to make a decision of what they really believe the truth is. Because, there's two sides to the truth. What he said, what she said, or they said, and then what actually happened. So keep that in mind. Just because you don't like a decision a judge made doesn't mean they're biased against you. It just means they evaluated the evidence and they made the decision in accordance with the law. So, like I said, for example, the Sixth Circuit, this is where you're going to find the judges listed. So these are some of our judges. There's way more than this. But you can click on their name and it'll take you to their practice preferences. So you'll see a picture of your judge, you'll see the courthouse, the courtroom that they're assigned to, their judicial assistant's email, their phone number, their contact information, and those practice preferences. So what they like to see in their courtroom or what they require. So that's probably something that I would highly encourage you to do, is once you file and you get assigned a judge, go check out your judge's practice requirements and make sure that you are fully prepared for what to expect in their courtroom, because their practice preferences will let you know how they run their courtroom and how they want things turned into them. So finally, conclusion, get your documents together. I always say before you even file, you need to have all your mandatory disclosures pulled apart, because it takes weeks to get this done, especially if you have kids. Anyone that has kids, especially little kids, knows you can't take your eyes off them for more than 1 second. So getting all these documents together is super time consuming, and you need to be prepared and have them ready, because like I said, 45 days goes super quick. So once you file, if you're the person filing the petition, you have 45 days after you filed to give your spouse the financial affidavit and those mandatory disclosures. And then if you've been served with the divorce papers, a petition, you have 45 days from the date you file your answer, which is, I agree with everything, please let's get divorced, or your counter petition, which says, I agree that we need to be divorced, but I disagree as to these things that my spouse is asking for. 45 days from the date that you file that, you have to give those documents over as well. So keep that in mind. Start setting aside money to pay for your costs. So the filing fee, process server, mediation, and attorney if you hire one. Start saving for those expenses that you're going to have. And keep in mind, when you're communicating with your attorney, every communication you make costs you money. So I always say for clients, to help them manage their expectations, to help that save them money, is when you think of a question, instead of just calling your attorney to ask, write it down. You may find after 2 or 3 days you have a list of 10 questions. So if you send 10 emails or make 10 phone calls, you're going to get charged for each one of those calls, and it may take a big chunk out of your retainer, and then you're going to be billed for that. Or you can consolidate all your questions into one email or one phone call and have the attorney do one-time bill for that to answer those questions. So keep that in mind. Your attorney will bill you for everything. So every email that they receive, whether they read it or they're a paralegal, they're a legal assistant, receptionist, everything somebody in their office does on your case, you'll get billed for it. So keep that in mind, because attorneys are expensive, they get expensive, and you need to keep that in mind. Draft your pleadings, fill out all your forms, double check them, triple check them before you file them, and then call for help if you need it. There are many ways to get an attorney. If you can afford one, you can go to legal aid. There's many legal aid agencies around the state of Florida. And you can also call local bar associations and get a referral to an attorney. Or you can just Google an attorney, look one up, or ask a friend who's had a divorce. Hey, you've been divorced. Did you like your attorney? Did you like your spouse's attorney? You have somebody you can recommend me to. So if you have questions that are not answered in this informational brief, and you need more specific guidance about your case, then I highly encourage you to talk to a licensed attorney to get some legal advice about your situation. So that's it. That's all I have for you today. I will make myself available if anyone has any questions. You're more than welcome to set up a consultation with my office. My office, I have an answering service, so if you call my office, you'll ask to be put on my calendar for a consultation, and then we can have a 30-minute discussion about your case. I can help answer any questions you may have, and if you decide to hire me or my firm, then we can represent you in your divorce as long as there's not any conflict of interest. So I hope this helps, and I wish you the best of luck.